Thank you. Yes. There are very few matters today, so no adjournment perhaps. You are praying for something?
Lordship, yes, I mentioned item number 8. It's listed for hearing, but my senior is indisposed, so if this matter can be listed after some.
Muaz Amir is there?
Lordship, he's not here today.
Acha, acha.
Yes, sir.
Yesterday he was there.
Lordship.
Okay. Ms. So-and-so,
Are married.
for the appearing for the petitioner, states that the conducting counsel, Mr. Muaz Amir, is indisposed today, and as such, she has prayed for some accommodation. Prayer is allowed. List this matter after 2 weeks.
Lordship.
Thanks, Lordship. Lordship, sorry for the indulgence. I'd like to mention item number 5. Now, this is a contempt matter. Now, the order has been complied with. There's been some delay in complying with the order, but because of the system that has been adopted by the state, now the petitioner has already retired from service. Now she has worked for 1 year. Because inadvertently we have issued an order extending her service for 1 year. Now, as per the new system, we call it the PIMS, Personal Information Management System. Money is transferred through e-pay. Now, though the amount has been approved by the government, to be paid to the petitioner, it has to go through her salary account.
Acha, the issue was non-payment of her salary during the extended period?
Yes.
Acha.
So now the Treasury has already given its clearance, Lordship, so the payment will be made in a very short while. It was last week that the Treasury account they have cleared it. So Lordship, may I pray that 2 weeks may be granted. In the meantime, we will apprise the court about the compliance of the court order.
There is no willful disobedience as such.
Yes.
So they have gone through certain process. And okay, within 2 weeks he may file an affidavit also. Or if he in the meantime,
I can place on record, Lordship.
if he meantime pays the amount and places by way of an affidavit, it can be closed.
Yes, Lordship.
Or affidavit may not be required also
Not required, Lordship. Yes.
if you agree. Okay. So Mr.
And Mozoi.
and Mozoi, appearing for the
respondents.
state respondent, submits that the directions given for compliance of the same has already been adhered to, and with the payments to the petitioner
Yes.
only remaining, and that the same would be done within a short while, within a short period of time. The petitioner has no objection to this. As such, he prays for some time. Petitioner, to which the petitioner has, counsel for the petitioner has no objection. List this matter after 2 weeks.
Obliged.
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 Yes, Mr. Takamasa.
Yeah, please, Your Ladyship. I'd like to mention item number 4, the contempt petition.
Okay.
Last occasion, the matter was listed on 17/7/2025. On that day, it was brought to your Honorable Court notice that service of notice are yet to be completed.
Acha.
However, I don't know what has transpired on 17, but it is again listed today.
Oh.
Since this is a contempt petition without effecting notice,
Yes, of course.
it won't be fair to go ahead.
Uh-huh.
I mean,
So, perhaps
yes.
service is not yet
Yes.
complete. Can I see the file
Can you
once?
see
Yes.
the records?
Item number 4, just show me the file.
Otherwise, we are also equally,
Uh-huh. This is in connection with some compensation.
yes.
Oh, such directions has been complied and that no. Acha, last time fees Sukhori.
Yes, Your Lordship.
Uh-huh.
My only concern is, since this is a contempt petition, this is a contempt petition, and the newly impleted respondents were allowed without objection for any other by the respondents. So at least the notice to be completed, otherwise we will set a wrong precedent.
No,
And overall, above all, it is a contempt petition.
Yes.
Uh,
On 10, 11 and 12 services awaited.
my
Yes.
lady, if we see the direction is only to the deputy commissioner to
Acha.
verify the spot along with the petitioner.
Ah.
The then deputy commissioner, they have done everything and they have filed their affidavit. Yes.
Yes.
So now nothing remains.
But the fact, who are 10, 11 and 12?
Yes, that is the issue.
Who
The
are?
newly incumbent of the DC,
Because
Oh, acha.
but the
Earlier one had complied.
earlier completed everything.
But then there is an application for implement, it
and
seems.
that was allowed.
And that was allowed. So at least we should go the way the court is going.
We should not say the wrong. We should not commit error with the.
At least let the notice be
fundamentals.
served. After that, if it is completed, it can be
Yes.
closed on the
If that is the
say next occasion on the
Otherwise, we'll say the new precedent going ahead without notice.
without.
effecting notice.
In fact, it is there in record, so it will not be very reasonable to leave them and then close it, right? So, Mr. Takamasa, appearing for the petitioner, submits that the notices on the newly
Completed response.
impleted respondents number 10, 11 and 12 was not complete, and the office note dated 14/11/2024 also reflects the same.
Yes.
So, Mr. Takamasa submits that this notice may be served, and after that, the contempt petition may be taken up for final disposal. The prayer is allowed. Since steps were taken when? Steps were taken only, it was taken long back, 14/11/24.
Last
Right.
year.
Okay.
If necessary, fresh step we can
Fresh
take.
steps, okay.
Yes.
So the prayer is allowed, the petitioner is allowed to take fresh steps. Before that you write, since the steps were taken long back, that is on November 2024, the petitioner is therefore allowed to take fresh steps for service of notice upon respondent number 10, 11 and 12 by registered post with AD as well as with usual process. List the matter after 2 weeks.
Kindly allow me to take the step within 3 days.
Acha, returnable within, petitioner to take steps within 3 days.
Yes, much obliged.
Please, Your Ladyship. Your Ladyship, may kindly allow me to mention item 1 and 6 on behalf of my colleague K. Angami. He is indisposed.
Acha.
So, Your Ladyship, I pray for 2 weeks' time.
Criminal appeal, it could have been disposed of today.
The
But then,
brief is with him, Your Ladyship.
acha. And 1 also.
Yes, 1 and 6 item.
Acha, 1 and 6 you write. Miss,
Mary.
Mary. Yes, Miss Mary, the public prosecutor for the government of Nagaland, states that the concerned public prosecutor who is dealing with the present case, is indisposed, and as such, a prayer is made for adjournment. The same is allowed. List this matter after 2.
My lord, my presence may be shown, my lord. I am for the petitioner here.
Acha, you are in item number?
One.
Ah.
PDP people.
Acha.
And Lordship, I am for respondent number 2 and item number 1, Lordship.
Acha. So, Acha, Mr. You're
MK Das, Lordship.
MK Das for respond number 2 and Mr.
PB4.
Yes. For respond number 1? No. Respondent
I am
number.
for the petitioner.
Acha, use for yes, of course. So and so for the petitioner, respondent number 2. Okay.
Lordship, this is interim, Lordship.
Obliged.
The interim and item 1.
Yes, in item 1.
Yes, Your Lordship.
Let me check once. Give me that item 1 file. Because I'm repeating once what happened. There was no interim order and it was extended during the mentioning hours. So I'll just check up once if it is at all there. Interim order.
7822 probably, Your Lordship. 7822.
Inclined to stay. Okay. Interim order passed earlier shall continue till the next date.
If your lordship can fix a date, if your lordship can fix a date in this matter,
It is better, Your Lordship, if you kindly fix a date.
Agree on a date by all the parties?
3rd of August, lordship,
3rd of August is a Sunday. 4th of
Oh.
August.
4th of August.
Listed on 4th of August.
Deeply obliged, lordship.
1, right? Not in 6.
One. Lordship.
6 will go after 2 weeks.
Obliged, my lady.
Yes.
May petitioner, Lordship, I'd like to make
Much
item
obliged.
7.
All I mentioned. What happened? Which matter?
Hearing item number 7.
Item number 7, why? Mr. Zamir is not there today.
Yes, Lordship, it's out of session. We went to Gauhati.
Guwahati?
Yes, there's special things at the
Acha.
rapporteur. So,
Okay. Mr. So-and-so appearing for the appellant, no, petitioner. Item 8, right? No, 7.
7.
Petitioner submits that the conducting counsel, Mr. C.T. Zamir, senior advocate, has some personal difficulty and as such he has prayed for some time. Prayer is allowed. List this matter after or on a date, on a fix. List this matter after 2 weeks.
develop like
That is a lordship. Lordship, I'd like to mention here in item number 9, lordship. Here, the living counsel for the respondent is additional AG Im Tim Song, lordship. Lordship, he has some personal difficulty today, lordship. So if lordship like this to list the matter after 2 weeks, lordship.
You are there.
And
You are there for respondent only. Same side.
yes, same side. And actually, the state has very little to say on these matters.
State?
State has very little to say.
Lordship, but I'm not briefing this.
But then still, even if, or you can be there on his behalf.
Lordship, since the brief is not with me, lordship.
The petitioner is also
Petitioner is also not, petitioner, you are there.
The petitioner. Lordship, if this matter can come up after 2 weeks, lordship, since I don't have
Mr.
Vijimomi.
V. Jimomi submits before this court that the additional AG,
Additional AG Im Tim Song.
the additional AD, Mr. Imti Imsong, has some personal difficulty and has prayed for some time. Mr. Sentienger is
appearing for respondents.
for
2, 3, 6, and 7.
2, 3, 6 and 7. I'll just record your presence. Objection. And Mr. So-and-so for the petitioner. The prayer is allowed. List this matter after 2 weeks.
For motion from the supplementary cost list, item number 10.
Acha. Sentienger, you are there. It's a bail application.
Yes, yes. My lord, this is the case which was moved on Monday. So I withdrew and then have imputed the victim.
Oh, POXO.
Yes, yes, who herself is the complainant in the instant case. By now, she, as is mentioned in the FIR,
She's major now.
yes, she is major now.
But at that time, she was
yes,
minor.
she is saying she was 17 years at that point of time in 2022.
Acha.
And FIR was registered in 2025.
After 3 years.
Yes, my lord.
But then, no way out. She has to be put
yes,
to
my lord,
notice.
my lord, I understand, my lord.
This is an application under section 480.
Yes,
482, I think, or 480.
480.
82 is anticipatory. I forgot.
My lord.
482 is inherent power. 482 is inherent power.
Oh, 480. No, for of BNS.
BNS
482 of CRPC. BNSS.
is 5 territory in hearing power.
But this is bail. BNS.
482 is anticipated repair.
And 480 is regular.
Yes, when bail may be taken in cases of non-bailable offence.
No, the BNSS.
Yes, this is BNSS.
No, he had given me BNS.
This, my lord mayor.
Yes, we have 480. Oh yes, okay. This is an application under section 480 of the BNSS 2023, praying for release of the petitioner on bail in connection with Women Police Station Kohima case number 0006 of 2025, registered under section 64, subsection 2, subsection clause 1, Roman 1, BNS, read with section 4 of the POCSO Act 2012. As it is mandatory under the law as well as under the Gauhati High Court rules that the victim has to be heard at every stage. As such, this court issues notice upon respondent number 2, the victim. Issue notice to respondent number 2. The petitioner would take steps for service of notice upon respondent number 2 through the office of the PP.
Yes, my lord.
That is the procedure.
Yes, my lord.
Through the office of the PP. List this matter after 2 weeks.
And keep your lord.
You have to give the copy to the registry.
If a text
Extra copy.
No, let the registry do. Let the PP office serve it. Okay. After 2 weeks,
My lord,
you can also mention if it doesn't come up.
my lord.
For motion, item number 11.
Hey, today I have given the CPC. I wrongly took it to my chamber. Item number 11.
May I please, Your
Yes.
Lordship? Your Lordship, this is an application under 428 of the BNSS for releasing the seized Tata truck.
For Jimma,
Yes, yes.
it was refused by the trial court, by the lower court. It is a Tata truck.
Yes, Lordship.
Where is the rejection order?
Your Lordship, I fell under, spoke under
Last page, page 15.
No, I want to see the rejection order.
Yes.
Yes.
at page 14, Lordship.
14, okay. Achha, without determination of the IO did not answer and so it was rejected. But otherwise, police does not want it for investigation anymore.
That is, yes, that
Yes.
is strong.
So what have you,
But
I mean,
unless the ownership, the owners is
huh,
that,
ownership.
yes.
Because under the law, you know, it has to be
yes,
either
Lordship,
given to the owner
Yes, Lordship.
or even to the what insurance authority or from whom it is seized.
Yes.
So show me the ownership.
Your Lordship, kindly go to page 11. That is the bill date which was executed between the owner of the vehicle as well as the purchaser, Lordship.
Otherwise, the vehicle is not registered in your name.
Yes, Lordship.
Not
we have-
registered.
At least let notice
Yes.
go.
Ah. But then whether it, notice is only to you.
Yes, but then I'll have to take instruction from the
Achha.
concerned party.
Where is the registration certificate of the registration of the vehicle?
Your Lordship, it's at page 12, Lordship.
This vehicle is registered in the name of Ajay Day.
Yes.
And from Ajay Day you have purchased it.
Yes, the applicant has purchased this vehicle.
This registration was of 22. Same Tata truck, right? What is the number? Registration number 2017. Have you annexed the FIR?
Lordship, when we go to page 9.
Ah. So this is if 2017. February 25.
Yes,
And the rejection order was
on 14,
725.
yes, 14/7/25.
And it was seized on
13/6/2025.
13 June
Lordship.
25.
Yes,
Oh, it was before the seizure.
yes,
They sealed it.
yes.
It took so long for getting the vehicle registered in your name.
Your Lordship, the applicant is trying to proceed for the change of name in the RC, but while on the process, on 13 of this June, in connection to this instant case, this vehicle has been seized.
There was the heading, registration. 12, okay. 77. I'm seeing whether the engine number and all are same. There is a declaration in May also, right?
Yes, Lordship. The page 13.
Yes, Miss Mary, you want to see the authenticity of the sale date or what?
Yes. Sometime will be given to me.
Otherwise, there is no use keeping the truck in the police station.
Yes,
Since they don't need.
It's already been-
And sale deed is before the seizure. And he has also, what I can do is dispose it off with a further direction to the police to examine a little and then give the custody to him.
Okay, Lordship. Okay, Lordship.
The ladyship,
Otherwise, you
ownership
again.
is still in dispute. It is not very clear.
Your Lordship,
So now
even
even the court is.
No, what you will do is you will examine through the police only the authenticity of this sale deed and all, or with the DTO office. But police can see it. Police will verify the sale deed and will give. That can also be done instead of keeping it pending.
Yes, Lordship.
The ladyship, a short time may be granted to me.
Lordship, even the registered owner has also given a declaration stating that.
That I have
yes,
seen. That I have seen. No purpose keeping it. I'll tell the police to verify. Okay. So, Mr. Swenson, for the petitioner. You are Pongener.
Yes, Lordship.
Yeah, T. Pongener for the petitioner and Mary.
S. Mere.
S. Mere, the the public prosecutor for the state of Nagaland. This is a petition filed under section 528, read with section 497 of the BNSS 2023, praying for release of the truck within bracket Tata bearing registration number NL 07 AA 2017, which was seized in connection with Meluni or what? Meluni?
Yes, yes.
MELUNI. Meluni.
R.I..
Oh, R.I. Meluri.
Yes, Meluri.
Meluri Police Station case number 0001 of 2025. Registered under section 25 within bracket 1 capital A Arms Act, read with section 35 of the BNS. There are other accused persons.
Lordship.
There are other accused persons
Yes,
in this
Lordship.
case
Yes, yes.
of BNS 2023. The petition, the counsel for the petitioner states that not counsel, sorry, not counsel. The FIR reveals that that informations were received regarding suspicious activities and mass movement of armed cadres and that on the said information the police personnel observing a suspicious activity by the driver of the Tata truck mentioned above. No, observing, don't write observing, the police has observed certain suspicious activity by the driver. And that the suspicious activity was revealed to the other police personnels. And that thereafter, the truck, along with 3 other trucks, were stopped, and upon search being made, many arms were recovered. The driver was interrogated. These items were not recovered from the truck.
It was recovered from the truck.
But then it's written on further interrogation and search, driver named Obaid gave away the location of recovery items mentioned below.
Yes, it was recovered from the possession of the driver. Lordship.
Okay, doesn't matter. It was recovered. On the interrogation, it was recovered. Yes, the driver was interrogated, to which he gave vague answers. However, on further interrogation, the driver showed the items. On receipt of this, on receipt of the said FIR, the police registered the case under the aforesaid sections. The petitioner filed an application for custody of the vehicle, that is the Tata truck bearing registration number NL07882017 before the Court of Chief Judicial Magistrate, First Class. Before the Court of Judicial Magistrate, First Class, fake. And by order dated 14/7/2025, the learned court was pleased not to give custody of the vehicle to the petitioner. The learned court observed that although the police had stated that they do not want the vehicle for any further investigation, however, the police did not give the information as to the ownership of the vehicle. And left the responsibility to find out the same upon the court. The court, as such, declined to allow the custody of the vehicle to the petitioner. Against the said order, the petitioner is before this court for custody of the vehicle concerned. The counsel for the petitioner states that the vehicle stands registered in the name of one Mr. Ajay Day and had annexed the registration certificate with the said petition. He, however, stated that on 24 February 2025, the said owner, namely Ajay Day, sold the vehicle to the petitioner by executing a sale deed, and which he has annexed with his petition. He has also placed the declaration affidavit of declaration. He has also placed affidavit of declaration affidavit by which the erstwhile owner, Shri Ajay Day, declared that he had sold the truck concerned to the petitioner and that the petitioner is the sole owner of the vehicle. It is no res integra, as has been held by the Honorable Supreme Court in a number of decisions, that the vehicle seized in connection with criminal cases may not be kept in the police station for long, as the same would lead to destruction of the said vehicle with time. Give me a decision. There are so many.
Your Lordship,
Okay, I'll write it in the chamber. I remember now I don't remember the names. You have, Miss Mary?
You don't have any.
No, there is one of them. I mean, there's the famous decision on, what that name is? Sundarlal Ambalal Desai, yes. In Sundarlal Ambalal Desai, reported in 2002-10, I think. 210 SCC, I'll give you the page number. Reported in so and so. I'll just take out it.
283, I think.
Uh-huh.
283. Paragraph 17 is relevant.
Acha, 283, right? Okay, wait. Let's take out. 283. Page number? No, not 283. 285. 283 or 285? 283 only, right? Perhaps it is not shown in some. No, I can take it out here. Yesterday Manu Patra was not working. Today it is working. Maybe there was some problem. I got it. 283 only. Page number 283. In which the Honorable Supreme Court had stated that it is of no use to keep such seized vehicle at the police stations for a long period. It was further observed that it is for the magistrate to pass appropriate orders immediately by taking appropriate bond and guarantee as well as security for return of the said vehicles if required at any point of time. It was further observed that in case where the vehicle is not claimed by the accused, owner or the insurance company or by third person, then such vehicle may be ordered to be auctioned by the court. And that if the vehicle is insured with the insurance company, then the insurance company be informed by the court to take possession of the vehicle, which is not claimed by the owner or a third person. When was the FIR registered?
On 13 June 2025, Lordship.
13 June
Yes.
2025. The Honorable Apex Court further observed that if the insurance company fails to take possession of the vehicle, it may be sold as per direction of the court. And that before handing over the possession of such vehicles, appropriate photographs of the said vehicle should be taken and detailed panchnama should be prepared. It is noticed that in the instant case, the truck was seized on 13/6/2025, right? 13/6/2025, and the application was moved before the learned court below on 14/7/2025. And after the rejection of the custody, the truck is lying in the police station. In view of the observations and directions given by the Honorable Apex Court, this court is of the view that the truck concerned bearing registration number NL 07 AA 2017 may be given in custody to the owner of the vehicle. the petitioner claims that he is the owner of the vehicle and have placed documents in favor of the same. Yet, this court directs that the police, before giving the custody of the vehicle to the petitioner, may inquire as to the ownership. And if the police is satisfied that the petitioner is the valid, or what do you say, is the rightful owner of the vehicle, the police may give the vehicle in custody to the petitioner during the trial of the instant case. It is further provided, before giving in custody, the police, or not the police, right? Giving in custody the necessary bond and guarantee for the return of the said vehicle, if required by the court at any time or at any point of time, may be taken. Further, Panchnama and all that, you know? Further, I said, no? Further, before handing over the possession, appropriate photographs of the said vehicle shall be taken and detailed panchnama should be prepared. With this observation, the instant petition is disposed of. Okay?
Much okay.
For admission, item number 2.
Admission. It's a bail again. Bail again.
Yes, my lord.
Pokso.
No.
Then, okay. You're praying for interim? Or I'll call
Yes.
the CD.
The CD has already been called. on
Oh,
the
is
last
it
occasion.
already been called?
Yes.
Oh, yes, I was there. Call for the case that is here? Yes. Acha, okay.
Lordship?
Interim was not allowed on the last day, right?
No, no, no.
Acha.
This court was of the opinion that CD may be necessary.
Okay.
Lordship, we have all been students at one point of time. So this young man,
We have all?
students,
Oh, students. Okay.
yes, yes, at one point of time in our lives earlier. So this young man, he is also a student at that relevant point of time, 20 years, 21 years. Now he has already turned 21. So he was pursuing his diploma course. And during our student days, we depend financially entirely most of the time on our parents. Sometimes we even feel guilty to ask money from them, because even if we complete our studies, there is no guarantee that we will get jobs, we will be able to support our parents during their old age. So we also look to earn, in short. So while using the popular social media platform YouTube, a pop-up came, advertisement. Now this pop-up came out not only in his cell phone, but in so many mobile phones across Nagaland.
That becomes viral, as it is said, right?
Yes, yes. So in that pop-up, there was an advertisement that
What is pop-up? I hardly understand these YouTube things.
YouTube advertisements.
Acha. In between a video, there are advertisements.
Yes,
Those
yes,
are pop-ups.
yes, yes, yes,
Okay.
yes, yes. And sometimes when you Google, there are, just below the screen.
So
there's
many
this-
advertisements.
Yes, yes. These are called pop-ups. So, saying that if you are interested to earn money. You can apply in this, like that. And then after an investment of a small amount, you will get this amount, this much of money.
And the young ones get attracted by all
Yes,
this.
so he clicked on that link.
On the
And-
pop-up.
Yes, on the pop-up. And he followed the instruction in the advertisement. In the advertisement, it was stated that he'll have to go to Job Blazer. Now, Job Blazer I have annexed. Job Blazer is a popular application
Job
software.
Pleasure?
Yes, Job Blazers. Blazer in the sense the blazer.
Blazers.
Yes, yes.
Okay, job blazers.
Yes, the same spelling.
Ah.
So he clicked on it, and then he went to that application, and then he was again told to go to RGA. RGA is Reinsurance Group of America. Now this is a very popular multi-million-dollar company, renowned company. So he had no idea that the RGA in Job Blazer was a fake company. So he clicked on it, and then he was told to invest. There were categories. So he invested 1,800 rupees. 1,800 was the lowest. And then if you invest 1,800, you'll be, after 1 month, you'll be getting 20,000, 30,000, 50,000, 1 lakh, like that. So this was a Ponzi scheme. So unaware. Ponzi scheme has been defined.
Ponzi.
Yes.
I've heard it before.
Yes, Black's Law Dictionary. I may be allowed to. List this.
Oh, it's not a new term.
No, it's not a new term. This is the 11th edition of the Black's Law Dictionary.
Gotcha.
A fraudulent investment scheme in which money contributed by later investors generates artificially high dividends of returns for the original investors, whose examples attract even larger investments. So, we know in India, in Northeast, and particularly in the Northeast, with tribals, we are gullible people. So we invest. There have been so many stories. My Lord is aware. So he was also attracted. He invested. He had no idea that this was a fake Ponzi scheme. Initially, for the first time, he received 20,000 with the instruction that he must do charity works with it.
We must
He must do charity works.
do charity work.
Yes. So he purchased stationaries and distributed it to his the students in his colony, school-going children and all this. He clicked photographs and then sent it to those people. Now after that, he received 50,000 twice. Meantime, that advertisement had attracted so many people from Nagaland, which the accused here, he did not create, he is not a creator of the application, neither is he creator of Job Blazer or the RGA application.
Only that he took photographs of the children and he had sent it.
Yes, to them, not to the society, to those people. To the RGI WhatsApp, through WhatsApp he sent. Now, some people, they even created centers.
Created?
Centers. Some centers, yes, some office was set up, yes. In Noklak district, in Mokchong district, in Kohima, in Tuensang. Where
Those involved in this one?
he was
Ponzi?
not at all involved in setting up of those offices in those districts. There is no allegation by the prosecution
Those were
for
by
that.
fake people? No.
Were created by genuine Nagas, genuine Naga people.
Genuine Naga people?
Yes, thinking that that application is authentic and genuine
Oh, okay.
business investment. So
Why did they set up the office in order to attract others? So you
yes,
invest and all this?
yes.
Okay.
But the accused here did not set it up.
Okay.
Some other people, because that particular advertisement was also seen by so many
Yes,
other people in their mobile phones and laptops. Now, those people set it up. These people who set up the offices in so many other districts, they again attracted so many investors. So people invested in them. Many people faced losses. After that, the offices in the districts were shut down. Because since it's a fraudulent scheme,
Later they came to know.
Yes, later they came to know, and the people behind the software, behind the job placers, the RTA fake applications, they vanished.
They vanished.
Yes. And they had no personal contact with those people. It was only
By
through-
that time,
yes.
they acquired a lot of money and they
Yes,
left.
yes. And the many people were left high and dry. Now they filed complaint before the police.
These people who had closed their offices.
Yes. Those people who have faced losses, they filed complaint before the police. The complaint was filed on 24th of October 2024 and registered as state crime at State Crime Police Station as case number 3 of 2024 under sections 111, 318 for fraud, extortion, cheating, dishonesty, all this. Now, after that, the accused, he was summoned to the police station on 12.
And what? FIR was lodged and your petitioner is arraigned as an accused.
No, he is not arraigned as an accused.
FIR
So-
was lodged because of the losses.
Yes,
likely.
yes, and those people who have benefited, perhaps, they were, and those who were acquainted with this, they were summoned by the police. I believe many statements were recorded by the police, and he was summoned on 12th of November. He
Petitioner.
went, yes, the accused, and the petitioner here is the mother.
Acha.
And on 11th of May this year, he was again summoned. Again, he went. And on 11th of June again, he was summoned. Again, he went, and on this third visit to the
41A notice.
yes, he was arrested on 11th of June. And since 11th of June, he is in prison. Now, unfortunately or fortunately, this year he had completed his diploma. He was supposed to go for degree course. Now the results of his diploma is annexed at page 38, annexed 12.
Yes.
He is serial number 13.
Serial number?
13, page 39.
Acha. Okay.
Unlucky number 13.
Lanu Younger Jamil.
Yes. This boy. Now, he applied for bail before the trial court.
This is in respect of higher secondary.
No, he is taking a Nagaland tool room at diploma.
Acha.
This is this thing.
Tool Ruber Training Center. Okay.
Engineering, I'm told.
Engineering.
Yes. So,
Diploma in tool and die making.
yes. Registered under the government of Nagaland Society, Industries and Commerce Department.
Yes.
Now, he applied for bail before the trial court, stating all these grounds because he was supposed to get admitted.
In that degree.
Yes, to the degree course. But because of his arrest and his continual custody in the instant case, he is unable to get admission, pursue his studies. Now he is only aged 21 years, he is a student, and he himself is a victim.
Yeah, he himself
Yes.
is a victim.
Now, my lord may kindly come to Annexure 6.
I have not gone through the FIR yet. Let's see.
The FIR
It's
is
okay,
at
the way you
Annexure
want to
3.
proceed. Prayer 6. Yes, 6
FIR is at page 20. This is a Sumuto FIR.
Acha. And pair 6 is the grounds of arrest.
Yes, Annexure 6 is the grounds of arrest. Now, in this grounds of arrest, this actually is not
Ground.
grounds of arrest.
Reasons.
Yes, as defined under section 47 of the PNSS. Nor does it meet the requirements of Article 22 subclause 1 of the Constitution of India.
Yeah.
These are merely reasons of arrest, that is section 35 of the PNSS. Now, this honorable court, I'll place only one citation in order to
Acha,
save this
just
honorable
before
court.
that, I'll just go through the FIR once.
Okay, Annexure 3, page 20. I may be allowed to read.
This is lodged by?
This is a suo motu FIR by the police themselves.
Okay.
Do the officer in charge, State Crime Police Station, Nagaland, Kohima. Suo motu FIR. Sir, as stated above, I would like to submit an application of FIR against RTA Company. This is the Reinsurance Group of America.
No.
Yeah, in full form. Company who is involved in duping its customers. The details are as follows. Brief of RTA Company. RTA introduced themselves as a humanitarian company who are deeply invested in the upliftment of the poor and the underprivileged. They introduced investment plans promising of huge returns specifically to uplift the underprivileged. They stated that they were an organization affiliated with the government of India. The investment plans offered by RTA were as follows. Daily profit of 3.33%, monthly profit of 100%, annual profit of 1,200%. RTA has even set up offices at Naka United Village, Tumukitima, Tuensang Town, Noklak Town, High School Colony, Kohima. Apart from the investment plans, the RTA has also carried out social work such as distribution of rations such as tea leaves, sugar to the senior citizens. A number of complaints has been received at the 1930 CFC FRMS portal from all over the state, with more complaints incoming at the time of this submission. As per the complaints, it is found that the victims share the web links to one another where they have to register themselves in the RTA platform using their mobile phone. Some victims have reported to have used mobile app which was downloaded from the web links that were shared. All payments reported were seen to have made through UPI/wallets such as Paytm, PayZapp, etc. It has been learned that the RTA app has stopped working on 24/10/2024 and the invested money of the victims are suspected to be siphoned off, resulting in monetary loss of the victims. The victims are seen to be from Dimapur, Mogokchung, Tuensang, Kifre, Kohima. This figure is likely to increase as more victims report the fraud in 1930 after realizing that they have been duped.
Some of the links.
Yes. And at page 22, this is the arrest memo. Yes. It is clearly reflected the date 11/6/2025. So the accused here. So, in my humble opinion,
Where is that 41A notice on 13/6 or 11/6? You have not annexed or what?
47 notice. It's annexure 6, page number 26.
He was called, right, 26.
Yes, page 26.
No, this is the grounds of arrest.
Yes, grounds of arrest. Now this is
41A notice where he was summoned to appear for giving his statement. He went once.
yes, annexure 4, my lord.
He went once. He gave his statement. Right.
Yes, yes.
He again went.
Yes. So this is the first notice.
This is the first notice on
Yes. Before
14th of November.
Yes. So
14th November he went.
Yes, he
appeared.
went on 12th.
Huh.
Yes.
Huh?
He went on 12th of November. This says before 14th
Okay.
November.
Then
Thereafter, he went again, but that notice I don't have.
acha. At that he arrested.
And the third occasion, he was arrested. So he has fully cooperated with the investigation. This young boy. And annexure 6, coming to annexure 6, I want to read this.
Grounds.
Yes.
Yes.
The section 35. DNSS. Grounds of arrest, I may be allowed to read. 1. To prevent the accused from committing further crime. 2. For proper investigation of the offence, such as collection of evidence/arrest of co-accused. 3. To prevent accused from causing the evidence of offence to
Drop, I don't know.
Yes, I am unable
Offence to-
Yes, tampering with evidence. 4. To prevent the accused from disclosing such facts to the
These
and we
are,
have co-accused.
these are according to the...
Section 35.
No, these are according to that decision of Supreme Court are regions of arrest, not grounds.
Yes.
Your Ladyship, this is the format which we have been using.
No.
Your Ladyship, may I please...
This
see
is
that-
what is written format for information, but
Your
then the
Ladyship-
police did not understand properly.
Your Ladyship,
Yes.
he is very much well aware that he will be arrested because 3 times he has been interrogated and there is a evasive nature of the petition. If your Ladyship rules the CD, your Ladyship will come to see that there is evasive nature of the accused because he keeps on changing his statement. First interrogation he was allowed to go, second also, but third interrogation they have come to know that he has been cheating the eye also. So all
He
these-
has been?
he is not disclosing, concealing the truth. So he was arrested on the 3rd occasion. And your Ladyship, this is the format which we have been using for
No,
grounds of arrest.
on what offense? For what offense
Yes,
he has
For
been
the
he is
arrested?
offense of
He is not the creator of Job Placer.
Because
RJ.
Suomoto FIR does not reveal anything.
Yes.
But
investigation is going on. So it cannot vitiate the FIR because the accused can be named at the stage of charge sheet also. So at this point of time, that is not so relevant, Your Ladyship. Your Ladyship, the charges, the offence are under section 1, subsection 3, subsection 4.
where is that, the registration of the offence? Acha. 1111346318. What are these offence?
Cheating involving delivery of property, it's 7 years, punishment is 7 years and fine. Cheating with knowledge that wrongful loss may ensue to a person.
So all 7 years.
Yes, yes.
All 7,
All the-
maximum
yes,
7
yes.
years. What is 1113?
1113 is criminal breach of trust by a person handling
acha.
property.
Okay.
Yes, Your Ladyship.
But how come 111 criminal breach of trust? Was he handed over any property?
Your Ladyship, like
No, there is no entrustment. Yes.
And 318, what you said? 318 is?
318 is criminal breach of trust. 318 aggravated form of criminal breach of trust.
Aggravated form of.
Criminal breach of trust.
Give me BNs. Oh, 111 is organized crime.
Yes.
Any continuing unlawful activity including kidnapping, robbery, extortion, land grabbing, contract killing, economic offense, cyber crimes, trafficking of person, illicit, so and so by any person or a group of person acting in concert, singly or jointly, either as a member of the organized so and so, organized crime.
They have blindly labeled the charges.
No. Investigation reveals otherwise. The Ladyship may kindly peruse the CD. He is
Acha,
the
you
person
can-
who has created the group, and then the flow of money is tracking. Right now, the investigation is going on, and it reveals that he is the one. The money, the timeline, it appears that he is the first person who has introduced it in Nagaland. So these things are there.
He's a pioneer. Acha, anyways,
The
just
Yes,
mark
I've
the
flagged
relevant
it. Yes,
portion.
I've flagged
Okay.
it.
3, 4 and 6, right? Whoever
Yes.
abates, attempts, conspires, knowingly felicitates the commission of organized crime.
The statement of the accused, CD3.
Apart from accused, any independent witness, whoever has said, this is Layu Younger, Jamir is the accused.
Yes, he is the accused. So his statement, he has admitted that I also created RGA Allied Group, VIP, that is CD3 page 2.
He may have created a WhatsApp group, but not the application.
And this is the first statement, then coming to the second statement.
These are
I'm reading
two
the
totally
first
different
Your
things.
lady.
There is no allegation that he has disproportionate wealth. I am sure the actual persons behind RJ will be quite wealthy by now.
Now, this opening of the group will not saddle him with any criminal liability. He might be just thinking
Your
he
ladyship,
will,
may
others
kindly
will
come
be
to the
helped.
second statement that was given on at CD 11, dated 10th May.
Downlines means more,
Yes,
More
yes.
money.
more
Downlines.
participants.
Yes, more participants.
Yes,
Yes.
more participants.
Yes,
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 yes. In Ponzi scheme, downline means more participants.
Acha. Why did he sell his mobile phone?
Your lady.
He said that he has sold his mobile phone which he has used to download the Blazor app.
Yes.
Further, he stated that so and so.
Yes. In the first instant, he said he has sold his mobile. Then it was not. If your lady will come to CD 12, dated 13th May, mobile was seized from his possession.
Received the B party details of one of the complainants mainly. Following mobile phones were seized from so and so. There can be more mobile phones. He sold once, but then these are nowadays boys
that is
carry two, three mobile phones.
That is the very handset which he is using for doing this scam. Yes.
But then I don't think so, Miss Mary. These are young boys who get into the trap of this, the desire
There
to
are
earn
thousands
money.
victims.
Yes.
Even I have seen elderly
So
people
unless-
near our
Yes,
places.
yes.
He used to search for
And why only
participants.
him? That is the issue. Why only him? If these people are to be arrested, don't those people who have set up offices in various districts of Nagaland, why are they not behind bars? Why only this poor boy? He
I do
has
not know.
yes.
No,
Who
where
are
is
behind
the
the bar?
where is the statement that he is the one who started it? Acha.
Yes.
He said that I got participants, right?
Yes, yes. So this very statement is relevant if your ladyship may come to CD3.
CD?
I also created that is relevant. I also created RGA elect
I
group.
also created
Yes,
RGA elite group.
Yes,
Now
yes.
may not be with bad intentions.
Your ladyship, as of now, he is not cooperating with the investigator. So the evasive nature itself does not warrant.
No, No, there is not much
So
difference
unless
between his.
further
Yes.
investigation is done, as of now, it's too early also to.
But what my opinion is, he's a young boy of 21 years. He got into that trap of earning money. And then, like so many, now you'll find hundreds, thousands, millions of these people who get into the trap of these fake
Yes,
companies.
yes, that I understand.
Even I would say one of my elderly person who has a son of 21 years, he also was searching for participants and he used to come to me and say, no, don't get me involved in all this, no, I don't want money like this. But then there are, so many people keeps doing it. And then he is 21 years, he is, in fact, he went to give his statement. Maybe he gave different kind of statement. But then he went. It's not that he eloped or it's not that he absconded.
It's not about the absconding to leadership. It's just that after the second interrogation, he has formatted all his mobile. That shows that the intention is not
No,
good.
yes, out of fear also he might do it.
Yes.
Let me.
A young boy being interrogated by the police. Yes. And my lord, one important issue I want to highlight. Section 35, if my lord may kindly go to section 35 of the PNSS.
Section 35 of
Yes.
BNSS.
Yes. And if my lord may kindly go to page 26.
No, wait. Section 35.
Yes. To compare and contrast. Section 35. Yes.
35 is what?
35 is
What's
when
this,
police may arrest
41.
without.
41.
No, yes, 41, yes, 41 of CRBC, yes. Now, when police may arrest without warrant. Now, if my lord will kindly go to section that 1B, Roman 2A.
The police officer is satisfied that
Yes,
such
that's
arrest is
it.
necessary
Yes.
to prevent such person from committing any further offence. Yes.
Yes. Now, if my lord will kindly compare it with the grounds of arrest at page 26 and
No, grounds of arrest, it is writ large that these are not grounds, these are
Yes.
reasons. As
Yes,
has been
yes,
said,
yes.
what is that judgment? After Bihan?
Bihan
No, not
Kumar.
Bihan, before Bihan.
Yes.
Before
The
Bihan.
2024 judgment, yes.
I always forget that
yes.
judgment, where it is written and it was quoted as to what will be the reasons and what will be the grounds.
Yes. Here also
What is that name?
this is a decision passed by Justice Debashish Parua. This before at Kohima bench, paragraph 20.
Acha, Vihan Kumar. There was
Yes.
another one?
Yes, if I may be allowed to read
Uh-huh.
paragraph 20. From a perusal of the above paragraph, it would be seen that the reasons of arrest cannot substitute the requirement of section 50 of the Code as well as Article 22 subclause 1 of the Constitution, inasmuch as the grounds of arrest are personal to the accused, wherein the accused is informed of all the basic facts on which he is being arrested, so as to provide him an opportunity of defending himself against custodial remand and to seek bail. Paragraph 23. This court further finds it relevant to take note of the judgment of the Supreme Court in the case of Vihan Kumar Supra, wherein the Supreme Court observes that if the arrest is vitiated, the person arrested cannot remain in custody even for a second. So here there is flagrant violation of Section 47 and Article 22 subclause 1 of the Constitution of India. As such, even on other grounds also,
Okay, what I'll do is... there
forgetting
is,
the other grounds, yes, even on this ground alone,
No.
he is entitled to bail.
Your Ladyship,
admitted-
there is no procedural lapses. Because if your lady may see that the arrest has been made after 3 interrogation and he is very well aware that he will be arrested in this connection. So even in the format it has been stated that the
If he
arrest
was
had
aware,
been made.
if he was
Kindly
aware, he
allow
would
me
have,
to
he would
complete.
have filed.
That the
a
arrest
disciplinary
had been made after imparting and communicating the basic facts constituting the grounds for his or her arrest.
Where?
Effect, that is at page 26.
Uh-huh.
Yes, that is very
That
clear.
typed portion.
Yes, type portion. Grounds of arrest has been given to the accused
that,
effectively in
that
the
is-
language, and after that they have signed. So their signature is there. Even the accused mother is a witness. And if this is not a ground of arrest, then your ladyship.
This is reason for arrest, not grounds of arrest.
No, this is ground of arrest. It's clearly a format for information of grounds of arrest is there.
But the
under section 47
but the
ENS.
contents are not grounds of arrest. These are regions. I'm talking about the
Okay.
other case.
Okay.
Before Bihan Kumar, there was another one which
Okay.
says that
But
communicating
you
him that you will not you will be prohibiting from doing such and such or further offence. Those are all regions. These are not
Okay,
grounds.
Your Ladyship, then, if Your Ladyship is of the view that there is procedural lapses, but the gravity of the offence, the procedural lapses cannot be override the gravity of the offence.
No,
That-
but then grounds of
The
arrest.
offence-
22(1) violation. Even one
Your
it is
Ladyship,
vitiated and
kindly
you
allow me
cannot.
to place two, because it's an economic offence. So I'm placing reliance on two judgments. Serious fraud investigation officer versus Nitin Johari. Para 11 and 15, I'm relying on para 11 and 15, and P. Chidambaram versus Directorate of Enforcement. Please.
Not this. Okay. So Chidambaram,
Yes.
which paragraph? 94.
Chidambaram is para 9 and 83. Here, anticipatory bail was rejected by the Supreme Court.
This is a classic case of money laundering.
Yes, it falls under this. Even the present case falls under this category.
A young boy getting into an website with online issues. Look at the current situation. Look at the circumstances. These are not staunch criminal. And pay paragraph 83.
Yes, 83. That is the concluding para. And then
This one.
And then in that serious fraud investigation office, para 11 and 15, Your Ladyship, may kindly please, para
11 and 15.
Yes, 11 and 15.
Okay, this is all?
Yes.
Right. This is an application under section 480 of the BNSS 2023.
My lord.
Read with article 226, not a writ.
Yes,
And
my
not-
lord.
There is no question of any writ.
Yes, my lord. But here, I have raised the contention that Article 22 subclause 1 of the
I'll
Constitution,
take note of.
which is why I have brought in, yes. Article
Just
22.
get me the decision of before Bihan Kumar. This is even in some of my orders it will be there.
I'll give in 2 minutes.
Okay. 480 of the BNSS 2023, praying for release of the petitioner on bail in connection with state crime police. Did I dictate all this before? Acha.
No, I don't think so.
In last case was also crime.
Yes.
Oh yes. In connection with crime police station case number 0003 of 2024, registered under section 111, subsection 3, 4 and 6, different brackets, and 318, subsection 2, 3 and 4 of BNS 2023. The FIR, which was registered suo motu, reveals that a company named RGA had duped many customers, and that the said company introduces investment plans promising huge returns, specifically to uplift the underprivileged. And that they have affiliated with the government of India. The said RG, it is further stated in the FIR that the said RGA, which affords profits on investments, had set up offices at various places in the state of Nagaland. It is thereafter stated that a number of claims have been received from all over the state, alleging that victims share the web links to one another, where everyone gets registered in the RGA platform using their mobile phone. It is also stated that the said RGA app had stopped working on 24/10/2024, and the money that was invested by the victims were siphoned off, resulting in huge monetary loss of the victims. On receipt of the FIR, the case was registered under under the aforesaid sections. During the investigation, it was found that the petitioner had also invested in the said app, or what? Invested his money and had invited many other people into the said investments. The police, as such, served him 33(8) what notices under? Served him notices under, in place of 41A, what is the new section? 33 something.
The summons has been issued under section 179.
179 of BNSS, what is that? Otherwise some 30 something. 179.
Yes, my lord. Police officers' power to require attendance of witnesses.
It is not akin to 41A. Okay, you're right. Issued summons. What did I say?
41 speaks about arrest by magistrate in the present PNSS.
No. 41 of CRPC.
Yes.
41A of CRPC, where in
section 35 PNSS.
and what is the difference between section 35?
When police may arrest without warrant.
It's 35.
Yes.
No, 35 is 41. 35 what? 35
of PNSS.
35. Do you have the comparison chart?
The police officer shall, in all cases where the arrest of a person is not required under
One
subsection 1, issue a notice directing the person against whom a reasonable complaint has been made or critical information has been received.
41A is 35 only.
Or reasonable.
Okay.
Yes.
Under 107, what did I say? Served his summon, served summon under section 179 of the BNSS.
My lord,
Mr.
the earlier judgment prior to Vihan Kumar,
What is the name?
Prabir Purkayasta.
Prabir Broadcaster. This is what I'm talking of. Thank you. And then, yes, so and so. Mr. Santianger appearing for the petitioner? Appearing for the petitioner.
Yes.
States that the accused person, in receipt of the accused person, after receiving the summon, appeared before the police officer and gave his statement. And that thereafter he was again summoned, to which the accused person again went and gave his statement. He states that the accused has gone 3 times, right? 3 times. Is it okay? Is it right, Miss Mere? Yes. 3 times, and given his statement before the police officer, before the investigating officer. Mr. Santianger further states that the petitioner cannot be arraigned as an accused in the present facts and circumstances, and that he is a victim. He is in fact a victim to the entire exercise, to the entire incident. He stated that he too, with the urge to earn money, found that app while searching, while
Browsing YouTube.
what do you say that?
Browsing.
Browsing, yes. While browsing
YouTube.
in his mobile phone. While browsing the YouTube channel in his mobile phone. He, on finding the app and he, on finding the app, saw that investing the way it was directed in the app would give him profits, and as such he registered himself registered himself with the desire to earn some money, and in the process he was directed to get more participants, which he accordingly did and got into the offense in question. He stated that there were many others, that 6 numbers of, where do I get it? Where they have set up offices, you said? He also stated there were many other.
In Tuensang?
Many other what? Many other persons who had invested in the said investment scheme offered by the RGA and had set up offices for luring other investors in the same. However, he was not involved in the same. The counsel further stated that apart from his non-involvement in the incident in question, the grounds of arrest were also as mandated under section 47 of the BNSS and are under article 22(1) of the Constitution of India and under section 47 of the BNSS were not served upon him. By showing the format for information of grounds of arrest as he has annexed as Annexure 6 in his petition, he demonstrated that the same were not grounds of arrest but are regions of arrest. as has been held by the Honorable Supreme Court. He as such states that non-serving of grounds of arrest is itself a ground for release of the person on bail. As such, the counsel prays that the accused person may be released on bail under the aforesaid circumstances. That is all.
My lord, my lord.
Miss Mary, S. Mary, right? Miss S. Mary, the learned public prosecutor for the state of Assam, the state of Nagaland, states that state of Nagaland by placing the case diary of the instant case has placed before this court that the accused person is involved in the offence in question, and he was the first one to start investing in the scheme offered by the AGA, offered by the RGA, and that he lured others into investing in the same. She also stated that he had given different statements every time he goes before the investigating officer on being called for. She placed the statement of the accused person recorded on 13/11/2024, in which he stated that he was the one who created RGA, ELITE, Elite Group. And she also, and thereafter she placed his second statement before the IO, wherein he had stated that he recruited 15 other participants and added them to the WhatsApp group which he had created. And that he further expanded his participants. He expanded his line of participants, or what? He expanded his number of participants, and that by that he had procured more profits out of the said investments. She also placed his statement wherein he had stated that he had sold his mobile phone with which he downloaded the concerned app. She thereafter placed his third statement. Oh, no, not third statement.
Is there at CD 17, dated 11 June 2025.
Acha, CD 17?
Yes.
Okay, just before that. She had also submitted that although the accused person said that he sold his mobile phone number, but then his mobile phones and SIM card were seized by the investigating officer on 13th of May 2025. She thereafter placed his third statement given before the police on 17,
dated 11 June 2025.
11 June CD is
17.
not there.
11 June.
This is still 10 June. Achha. she also placed the third statement, I've already stated, no? Which was recorded on 11th of June 2025, wherein he had stated that he had formatted both his phones used for downloading the app concerned. And that he had not sold his phone as he stated in his previous statement. The learned public prosecutor also placed reliance on two judgments. These are both Supreme Court,
Yes, yes.
delivered by the Honorable Supreme Court of India, Supreme Court. One, in P. Chidambaram versus Directorate of Enforcement, reported in
AIR 2019 Supreme Court 4198
yeah.
2019.
2019 is 2019 different. AIR 2019 Supreme Court 4198, by which the Honorable Supreme Court had observed that in cases of money laundering and other such economic offences, pre-arrest bail may not be granted. She also relied on the judgment passed in serious fraud investigation case versus Nitin Johari, double T. Nitin Johari, reported in AIR 2019 Supreme Court 4380. By which the Honorable Supreme Court has observed that economic offences constitute a class apart and the same should be visited with a different approach while considering bail. I've heard this is all. I've heard the parties. I've heard the counsel appearing for the party and the learned PP. Sit now, Miss Mary. It is the FIR lodged in the instant case reveals that the offence against a company, namely RGA company, who is stated to have cheated many customers. It revealed that the said company, although introduced investment plans with the alleged purpose, with the so-called purpose to uplift the underprivileged, the main purpose of the said company was to cheat and appropriate money from the innocent customers. The said FIR was against the actions of the RGA company. The FIR revealed that the victims shared the web links of the said company to one another, and that they all registered themselves in the RGA platform through their mobile phones. And that it was learnt later that the RGA app stopped working and the invested money was siphoned off by the said company, don't write, was siphoned off. The accused person was not arraigned as an accused as an accused in the said FIR. The FIR was solely against the illegal actions of the aforesaid company. However, during investigation, it was found out that the accused person used to share the links, right? He used to share the links with others. And this is what is stated in case diary. He used to share the links with others. And in finding the same, the investigating officer summoned the accused person under 179
BNS.
of the BNSS. Although it is seen in this statement given by the accused person before the IO that he created the RGA elite group, however, it is not clear as to whether he was aware that the said RGA group, that is the parent group, had the intention to actually dupe the customers. Further, although he said that he invited other participants to the said group to earn more money, but then it is not clear as to whether he did it to cheat those persons or to make all earn money, and in the process he earned some more. The further statements of the petitioner or of the accused person that he told the IO that he had sold his phone but he had not, will again not criminalize him in the said offense, in as much as
Lordship, actually, the IO told the accused to deliver his phone at Jumukutima police station, which is a different police station from the state crime PS, which he actually did.
it's okay, I mean, it's not right
Yes,
to go.
but it appears
He being a 21 years of age, lured and all, I am giving the bail with other conditions.
My lord, my lord.
And then let's see, if he violates the condition, they'll come for cancellation, okay?
My lord, my lord.
And then he also said, no, he sold his phone, but he had not. But then the same will not make him a criminal, in as much as make him a criminal name. I said something else. Will not make him liable for any offense, in as much as he being a young boy of 21 years of age, must have got scared with the gamut of the allegations and the offense and had stated as such. The further argument of the learned counsel appearing for the accused person that grounds of arrest are not supplied to the petitioner, the same has basis in the facts and circumstances of the case. The format of grounds of arrest, which is annexed with this petition, first, right? Although a format for information is annexed with the petition, the contents of the same does not show. Contents of the same do not show that they were the grounds of arrest. Rather, it shows that they are the reasons of arrest. The Honorable Supreme Court in Prabir Purkayastha versus State and City of Delhi reported in 2024 8 SCC 254 had observed Do you know the paragraph where it is said reasons and grounds?
I don't have the book with me.
It was nicely written somewhere.
Otherwise, Vihan Kumar.
No,
in
no. Here
paragraph
it is.
21,
Here
yes.
it is. Here it is more elaborately
Well,
explained about reasons and the grounds. Yes. Wherein the Supreme Court has observed in paragraph 48 of the same that reasons of arrest that informing the accused person about that in what did I say in between initially? I mean, two lines from the top. The Honorable Supreme Court in no 48 of the same that reasons of arrest 48 of the same that reasons of arrest and grounds of arrest are two different phrases. The contents, such as to prevent the accused persons from committing any further offense, comma, for proper investigation of the case, to prevent the accused person from causing the evidence of the offense to disappear. Did I go fast? To prevent the accused person from causing the evidence of the offense to disappear or tampering with evidence in any manner, comma, to prevent the accused person from making any inducement, threat or promise to any person acquainted with the facts, etc., are regions of arrest. Whereas grounds of arrest should contain all such details in the hands of the investigating officer which necessitated the arrest of the accused. It further observed that the grounds of arrest informed in writing must convey to the arrested accused all basic facts on which he was being arrested, so as to provide him an opportunity of defending himself against custodial remand and to seek bail. As such, it is observed that grounds of arrest would invariably be personal to the accused and cannot be equated with regions of arrest, which are general in nature. It is noticed in the aforesaid format that the petitioner was informed only the case in which he was arrested and the offense which is registered against him. Full stop. The further stipulations made in the said format, that is to prevent the accused from committing further crime, to prevent him from causing evidence to disappear, to prevent him from disclosing facts to the co-accused, and to and for collection of evidence to arrest the co-accused are all regions of arrest, as is clarified by the Honorable Supreme Court in the aforesaid judgment. The police, they don't understand. See, in the format, in the bold, it is written rightly, ground of arrest should contain all this. But then they give regions of arrest. You make them understand.
Yes.
Although, in the said format, the requirement is provided for as to what grounds of arrest should contain. But the same was not understood by the police, and what was given to the accused were only reasons of arrest. Further, under section 48 of BNSS, you're able to follow, no? Further, under section 48 of BNSS, it is provided that even the family members of the accused person should be informed of the grounds of arrest. Right? Under 48, yes, Sentianger? Under 48, even family members,
Yes, my lord, my
copy
lord, my
will not do.
Yes, my lord, my lord. In
Okay.
Vihan Kumar, that is also discussed by Justice N. Koteshwar Singh.
Everywhere. And so, for even so and so. In the instant case, it is seen that the said format, which actually contains reasons of arrest, a copy thereof is given to the relative, to the mother, not relative, to the mother of the accused. But the provision under section 48 is not followed. It is here or in Vihan Kumar, it is said that 1 minute incarceration in violation of 22(1) is vitiated and immediate release. Where it is said?
In Vihan Kumar.
Vihan.
Yes.
Vihan Kumar, you have given.
1 second. In
Where
para
it-
14,
Just give me that. Have you given the?
in the last sentence, my lord.
The non-serving of grounds of arrest, as provided for under Article 22(1) of the Constitution of India, non-serving of grounds of arrest, which is in violation of Article 22(1) of the Constitution of India, makes the arrest unconstitutional, and the violation thereof vitiates the arrest itself. Vitiates the arrest itself. The continued custody of such a person is also vitiated thereby. In the present case, the arrest is as such vitiated, and the accused person is liable to be released forthwith. This court, therefore, both on the findings on merit of the case, as well as on non-serving of grounds of arrest, is constrained to release the accused person on bail. As such, accused person, namely, what is his name?
Lanuyang Jamir. Lanuyang Jamir.
Lanu Younger Zamir, akin to our acting Chief Justice names. Lanu Younger Zamir, former, be released on bail on furnishing of a bail bond of rupees, small boy, 20,000, with 2 local sureties. Government servant not required.
Government servant, let it be government servant.
with two local sureties, one being a government servant,
My lord, my lord.
he might again go away. Okay, there's gamut
Yes,
of.
and
There is risk of hindering the investigation.
That I will give.
and he is a student. Now he may be required to leave Nagaland for higher studies.
And then you take leave.
Yes, so that
But you give a small application for
yes,
examination.
yes, that room may kindly be granted. And under
He should not go out of station.
No, we cannot destroy his future also. With the leave of the court.
yes, with the leave of the court. Yes. And under section 180 PNSS, audio and video recording of statement is also allowed. So even if he leaves station,
That
police
police will do.
Yes, my lord.
And then, so furnishing with two local sureties, one being a government servant in the state of Nagaland, to the satisfaction of the Chief Judicial Magistrate. No, Subdivisional Judicial
The
Magistrate.
trial court.
The trial court.
Yes.
I think I got some order of the district and session judge
Yes,
of
madam.
the trial court to the satisfaction of the trial court with the following conditions. One, the petitioner would cooperate with the investigation and would appear before the IO as and when called for. Two, he will not hamper with the evidence. He will not tamper with the evidence or influence any witnesses connected with the case. He will not leave the jurisdiction of the trial court without the leave of the said trial court. Bas.
Now, my lord, if it can kindly be considered, the trial court is at Kohima. Now he lives at Dimapur, his parents' place. It's at because
Charge sheet is submitted, right? No.
not yet. Not yet.
So what I'll do is IO is of Dimapur,
Yes.
right?
Yes,
So without the leave of the IO,
my lord, my lord.
okay,
My
as
lord,
well as
my lord.
the trial court.
Yes.
Yes, my lord. Then if the jurisdiction can kindly be added, the trial court jurisdiction as well as Dimapur, because his ordinary residence is at Dimapur. So if it is the jurisdiction of the trial court, then the jurisdiction is only Kohima.
Offense is at Kohima. And
Yes,
so,
yes.
okay, you write, before that, he being
The FIR is
third,
registered at Kohima.
third condition you write, he being a student would have to go to other places, and as such, he will not leave without the permission of the investigating officer
My lord.
of the said case, as well as the trial court of the concerned place as required.
My lord, my lord,
He will have to
my lord, my
take.
lord. I am deeply obliged.
This bail application is disposed of.
Much obliged.
There are so many. Oh, you take your dictionary here. Ponzi. These dictionaries, as well as medical jurisprudence, as well as jail manual, should be made smaller. Right?
Yes, my lord.
They're so big, difficult to handle. Medical jurisprudence is so difficult. Yes.
Everywhere
then-
it is becoming thicker.
Yes. I will give you this the case diaries, the judgments. Give it to them, I mean, respective persons. Okay.
For admission, item number 3.
Yes.
On the last petition,
Wait 1 second. What is this about?
there's a criminal petition against criminal revision filed against the writ petition filed against MP notice dated 11/3/2025, wherein the Dimapur police has inquired us to appear before the court, before the police station, Your Lordship, wherein the agreement or the agreement between the petitioner and the private respondent has been filed in Gauhati. We filed this criminal writ petition on the basis that it lacks jurisdiction.
Acha. Today it has come up for admission.
Yes, Your Lordship. And the last occasion, the private respondent was supposed to file affidavits, Your Lordship.
That has not been done. Where are the private respondents? You have not filed your affidavit in objection. Okay, today they can let them file the affidavit in opposition is not required in this criminal petition, but objection perhaps they want to file something. Since it is on jurisdiction.
Yes, Your Lordship.
Miss So-and-so? Appearing for respondent number 3. You are for? Mr. Jhimomi appears for 1 and 2 and Mr. So-and-so appears for the petitioner. Miss So-and-so? Appearing for the respondent number 3 has prayed for some further time to file the affidavit in objection to the instant petition on the ground that she had not received the proper instructions from her client. Prayer is allowed. List this matter after 2 weeks. In the meantime, Ms. So-and-so will file the objection because no further time will file the objection.
Also, there is an interim order.
There is an interim order.
Yes, Your Lordship. Order dated 9/4/2025, Your Lordship. 9/4/2025.
Yes. What order you are saying?
9/4/2025, Your Lordship.
9/4/2025. Read the last paragraph. Accordingly, this court, in the interest of justice, stays. Acha, I didn't find it. Sorry. Okay. List the interim order passed earlier shall continue till the next returnable date.
Lordship, if I may, there is one more request, Your Lordship.
Date.
Lordship, my senior, Mr. K.K. Mohanta's name may be reflected. Lordship, his name is not.
In this order, you need not. What is?
In the cause list, Your Lordship. In the cause list.
Oh, it's in the cause list. It's not reflected.
No, Your Lordship. That is why on the last.
Yes, the registry may reflect the name of Mr. K.K. Mohanta, learned senior advocate, in the cause list for the petitioner. Okay.
Like Your Lordship.
For orders, item number 12.
Contempt.
Yes, Your Lordship.
Wait, one second.
Order of this court has been complied. So
12, right?
Yes.
True.
no.
Yes, item 12, Your Lordship.
It is complied.
Yes.
And you know it is complied.
Yes, Your Lordship. They just give me a copy of the appointment order.
Oh, now you have come to know
yes.
that it is complied.
Yes.
So let her go through or what?
No, Your Lordship.
We have already
Dispose of the
intimated them to collect the appointment order.
What do you have to say?
Yes.
Your Lordship, we can dispose of we can disclose the matter.
Acha, okay. I thought your senior must be coming. What is this direction? What are the directions?
The direction is to make a
Your
Page
Lordship,
number?
Page 17, the relevant portion.
17?
18, yes, Your Lordship.
Okay. Paragraph 11 or 12?
Paragraph 12 and 12.
There is a vacant post of Chowkidar available under the Imam, under the office of Imam, and also by all leaders in the India. Achha, okay, right? This is an application. This contempt application was filed under section 11 and 12 of Contempts of Court Act 1971, read with Article 215 of the Constitution of India and the Article 215 of the Constitution of India and the and the Contempt of Courts Gauhati High Court Rules 1977 for willful and deliberate violation of the judgment and order dated 7/11/24 passed in WPC number 295 of 2022. It was directed by the learned single judge. No, not it was directed, cut it. During the hearing of the writ petition, being writ petition number 295 of 2022, it was submitted that a vacant post of Chowkidar was available under the concerned department in the office of SDO PWD Cheng Town in the district of Mon. During the proceeding of the said writ petition, an interim order was also passed on 15/12/2022, directing the respondents not to fill up the said post. Full stop. As such, this Honorable Court, by order dated 7/11/2024, had directed the respondent number 2 and 3 therein, that is, Engineer-in-Chief, Nagaland Public Work Department, and Chief Engineer, PWD, Government of Nagaland, to take steps to pass necessary orders for appointment of the petitioner in the said vacant post of the Chowkidar. Full stop. This court had thereafter directed for continuation of the interim order dated 15/12/2022 until the post is filled up. The court had further directed the respondents to carry out the orders within a period of 60 days from the date of receipt of the certified copy. Today, when the matter is taken up, Miss V. Shokri, right?
Yes.
Spelling is different and pronunciation is little different.
SUOKHRIE.
SUOKHRIE. Shokri.
Yes.
Miss Shokri. What Shokri?
V. Shukri.
V. Shokri. The learned public prosecutor for the state of yes, appearing for respondent number 2 and 3.
For all the respondents.
Or for all the respondents. Appearing for all the respondents has placed an instruction placed an order dated, date is not there,
At the last
25/6.
Yes.
Dated 25/6/2025, by which it is ordered, consequent upon approval of the government and interest of public service, the incumbent is hereby appointed on landowner basis in the office of Imam under Nagaland Police per allowance. Details are retired. The petitioner's name is Phompa Konyak.
Yes.
And what landowner basis? He was to be appointed as Chokidar.
So we have as a multitasking staff.
The appointment shall be on probation. On completion of probation, he shall be liable.
The post of Chokidar was lying vacant, so we are supposed to. So now she has been appointed as a multitasking staff.
Where is that multitasking staff? Oh yes, I've got it. Yes, is hereby appointed as multitasking staff on landowner basis.
Yes.
Landowner basis.
We have a policy for appointment on landowner. So the petitioner, they are claiming.
We have donated the land. That's why we
Oh,
were
oh.
appointed. Yes, Your Lordship. On the
That
basis
is
of
what
that.
is.
Yes, yes.
So you will be given a land also.
No, just the
No.
appointment.
He will be given appointment.
Yes. As a multitasking. What landowner basis means?
Means he donated the land for the establishment of the government institution.
Acha.
Yes.
This person
Yes.
had donated
Yes.
a land.
Yes. His
Acha.
parents.
Okay. He is a chowkidar. It's difficult to
father,
consume
his
like a
father.
chowkidar donating a land.
His father had donated
His
the land.
father
earlier.
donated the land.
Okay.
So none of the family members availed the appointment. So now she is coming to the court for asking for appointment on land ownership basis. Because the land system in Nagaland is different.
Different.
Yes.
Okay. Has placed the order by which it is reflected that the petitioner petitioner has been appointed as a multitasking staff on landowner basis in the office of Executive Engineer PWD, Kohima, under Nagaland Public Work Department in pay level 1 of the pay matrix plus other allowances as are admissible. The said office order is kept in records. The copy of this office order was also given to the counsel appearing for the petitioner. Who on perusal of the same is satisfied. Since the order of the Honorable High Court is complied with by giving appointment of the petitioner to the post of multitasking staff in the said department, this contempt petition may be closed. This contempt petition is closed. Yes. Petition is disposed of.
For orders, item number 13.
Or you can add a line that showing necessary compliance has been appointed and necessary compliance has been shown. Yes. Which? Order? This is an order matter.
13, Lordship. Respondent number 2 still awaited, Lordship.
Item number 13.
Yes. Notice has been issued upon respond number 2, return awaited. This is otherwise quashing of FIR. No. This is against judgment. Yes, Lordship.
Oh, this is against conviction.
Yes, Lordship.
Okay. This is conviction under 498A.
498A,
354, 506.
498 fair and respondent number 2 is the victim.
Lordship.
And service is otherwise not required. Only in POXO cases it is required. Records are here. Records have not come, right? No. Or records have been called for. Not called for.
Not called for.
No, we have to see. Records not called for. Not admitted also. Yes. Mr. So-and-so, heard Mr. So-and-so and so-and-so, Jimomi, the learned public prosecutor. It is seen from the office note dated 22/7/2025 that service upon respondent number 2 is not effected yet. Since the steps were taken recently, the service upon respondent number 2 may be awaited further. In the meantime, the registry may call for the trial court records in connection with sessions case number. Where is the judgment?
Page number 64.
Yes. No, this is CJM. Where is session judge's order?
92, page number 92.
I think page?
Page number 92.
92. Both the records may be requisitioned. Okay. So registry may call for the records both from the court of Chief Judicial Magistrate in connection with GR case number 105 of 2021, as well as from the court of Principal District and Session Judge Mokokchung, Nagaland, in connection with Criminal Appeal number 1 of 2024. List this matter after 2 weeks. This is the last matter. Hearing are not done by the advocates here. Next time when I come, I'll make sure all of the advocates do the hearing. I'll not give the adjournments. You tell them.